Good morning. Come on, you can do better than that. Good morning. All right. Who won last night? Money. Talking about money. How many losers? Well, I'm surprised you're here this morning then. Maybe stick to what you do well, right? Stay off the tables, come sit in the classroom. Yeah, there you go. We've got a fabulous panel lined up for you this morning. How many were in here yesterday? Hands. All right. This is kind of a little bit of a continuation from that. And let me just start off and introduce our panelists today. Jessica Rich, who's right there, the only lady on the stage, so she shouldn't be hard to find up there. Jessica is Associate Director of the Division of Financial Practices within the FTC and oversees enforcement and policy work related to debt relief fraud, collections, payday lending, auto lending and leasing, mobile payments, and other finance-related consumer protection. A 20-plus year veteran of the FTC, she has developed regulations including the FTC's Children's Online Privacy Protection Act, Graham-Leach-Bliley Safeguards, and Fair Credit Reporting Act disposal rules, testified before Congress, and spearheaded policy initiatives. Big hand for Jessica.
Thank you.
All right, sitting right beside her, and she has two guys, but the guy, let's say, with the glasses on, okay? And a lot of you know Sean over here, so. This is Bill Brauch. Bill is Director of the Consumer Protection Division in the Iowa Attorney General's Office. Bill oversees the AG's consumer protection litigation, legislation, rulemaking, and education efforts. He currently serves as the chairman of the Automotive Working Group within the National Association of Attorneys General and participated in the FTC's Roundtable Series. Big hand for Bill. And down on the end, Chris Martin, of course, is a dealer from North Carolina. He is, well, as of Monday afternoon, he is now currently the president of NIADA. And during the past 12 months, he has been the chairman of our Legislative Regulatory Affairs Committee. Sean Peterson, of course, you know, is our counsel for legislative regulatory matters. Of course, Sean and Chris both were up here yesterday. And Sean is going to act as moderator today. Now, I think what they're willing to do is, as they are making certain presentations covering certain topics, if you have a question or something, certainly wave your hand. Try to get Sean's attention because I'm going to exit, and I'll be back probably about 20 minutes before the end of the session, and we certainly will do a Q&A session then. So, Sean, it's all yours, buddy.
All right, thanks, Mike. Morning, everybody. We are glad to have you with us today. We're very pleased to have Jessica and Bill with us. Jessica and I met a couple months ago in D.C. This is the first time that we've had the opportunity to meet. She has a wealth of experience, and we asked her to come and speak at our convention. She didn't bat an eye, and we're privileged to have her. She's going to speak first on a couple of issues that the FTC is involved with as it relates to you. Bill and I have known each other for almost a decade now, I guess. Bill and I were colleagues in this National Association of Attorneys General group. Bill's got a wealth of experience in automotive issues, and we enjoy talking Big Ten football. He is a Badger, and I'm a Buckeye, and we beat him this year, so we're going to brag a little bit. But they got the Rose Bowl berth, so. We are privileged to have our rock star with us. Chris indicated that after our presentation, he'll be in the back to sign autographs of the newspapers that were left on your door stoop this morning, so bring a Sharpie because he said he was out. We'll first hear from Jessica, and we want to emphasize, too, as we go along, if questions come to mind, please feel free to wave, come up to the microphones. We may have some runners available that we can get the microphones to you. We want this to be as interactive as we can. We want to address the concerns, questions that you have, and Jessica and Bill have certainly expressed an interest in hearing what you have to say, and they'll tailor remarks to the questions and concerns that you've got. So let's turn the time over to Jessica.
Thank you very much. I'm really delighted to be here and meet with so many people in the auto industry and to talk about the FTC activities and priorities that affect you. I have to admit, my big question coming in here today was how many women would be in the audience, and I'm delighted to see a few. I may be the only woman on the stage, but I see there's a bunch of women in the audience. As I hope you know, the FTC places a very high value on relationships with industry trade associations, among other stakeholders. It's a great way to learn about how the industry operates and, the products, the services, the benefits available to consumers. As you may know or may not know, the FTC, it's a fairly small federal agency as agencies go, but it has a very broad consumer protection mission with jurisdiction over almost every entity in commerce. There's just a few exceptions. Our primary source of authority, I just want to give you some background, is Section 5 of the FTC Act, which prohibits unfair and deceptive acts or practices. And we also enforce a number of statutes, special statutes, like the Fair Credit Reporting Act, Gramm-Leach-Bliley Act, and the Do Not Call. Many of those affect you. We are primarily an enforcement agency, but we also have some regulatory authority. Many of our enforcement and regulatory activities affect auto dealers directly or indirectly. For example, you're subject to the Fair Credit Reporting Act and its provisions governing creditors that use credit reports and furnish Consumer Report Agency information to the consumer reporting agencies. And you're also subject to Gramm-Leach-Bliley data security requirements. And I know there was a recent settlement just out against an auto dealer related to that, and I can talk about that later if you're interested. As I'll discuss more in a moment, we now have specific authority over auto dealers through the recently passed Dodd-Frank Act, and we've, of course, been administering the used car rule for a while. Over the years, we've had very healthy dialogue about requirements over the auto industry, and even, should I mention, some lawsuits by your sister organization. And in most cases, we've benefited enormously from the back and forth. As I mentioned, we're a relatively small agency, but we use a lot of different tools to maximize our impact. One key tool is education. When we bring a case, we always issue, or usually issue, some sort of educational materials to consumers and to businesses. We also use workshop studies and reports to focus on issues of concern. And another tool is working with our partners, like Bill Brauch and other state regulators. We work very closely with our partners to bring enforcement sweeps, to coordinate messages, and to generally develop a better understanding of the industries we're overseeing or working with. And we're obviously working closely with the CFPB as they get up and running in the financial regulatory area. With that background, I'd like to talk about the FTC's current plans and activities, and specifically how they relate to you. And I'll focus mostly on the financial area because that's my area of expertise now. I come from a privacy background, though, so I can answer questions about that, too. And first, I'm going to talk about our general priorities and plans and how they're affected by Dodd-Frank and our work with the CFPB. And then I'll focus on some specific activities we're undertaking with respect to auto dealers. So generally, the FTC right now is currently focusing on 5 areas in the financial marketplace: debt collection, payday lending, mortgage and other debt relief scams, mobile advertising, and other use of mobile technologies in the financial area, which is really emerging, and of course, auto dealers. Many of our recent activities are focused on activities, on practices preying on financially distressed consumers, but we're also looking ahead to spot new trends in the area, which is one of the reasons we're looking at mobile. We think that's going to be a big area, including for auto dealers, at least eventually. In terms of Dodd-Frank, the law that overhauled the financial regulatory scheme and created the CFPB, We have the same enforcement authority we did before its passage. I like to emphasize that because that's the truth. And in fact, as you may know, Dodd-Frank gave us additional authority in the auto area. In particular, it gave us rulemaking authority to address unfair, deceptive practices by auto dealers. And it also gave us primary enforcement authority over auto dealers by giving the FTC authority over all auto dealers while limiting the CFPB to buy here, pay here dealers. That was a hotly negotiated provision that I'm sure that some of you were involved in. You wanted us, which is always a mixed thing for any enforcement agency, but you got us. We're coordinating with the CFPB where our jurisdiction overlaps. But we're taking our primary areas of responsibility really seriously. Our goal is to stop unfair and deceptive practices without imposing burdens on legitimate players in this industry. In other words, to borrow from the title of this session, to even the playing field, to level the playing field. So let me start by talking about some workshops we conducted in the last year, which Bill participated actively in. With Dodd-Frank's grant of new rulemaking authority to us in the auto area, our first step was to learn about the issues and gather information, which is, of course, should be anyone's first step. We know how important cars are to consumers. For most consumers, the purchase of a car or truck is the most expensive financial transaction after their housing. Car ownership is essential to finding and maintaining, often essential to finding and maintaining a good job, buying food at reasonable prices, accessing health care, and fulfilling any number of daily obligations. Our workshops focused on consumer experience as they purchased, financed, and leased their cars. That's the focus of the law, and that's the focus of our inquiry. We held 3 workshops in Detroit, San Antonio, and Washington, D.C. Some of you may have been there. And we also sought public comment and got a number of public comments. Between the workshops and comments, we obtained input from a huge variety of stakeholders, including companies, trade associations, financial institutions, consumer groups, individual consumers, military organizations, and state law enforcement agencies. And we've also talked to various people since the workshops and reviewed cases that are brought in this area over the years. And we're open to talking to anyone that wants to talk to us as we move forward. Through all of this, we learned about the kind of packages, financing and leasing packages dealers offer consumers, whether consumers understand them, the types of misrepresentations that may be occurring in this industry, and many other issues. At one of these workshops, we also specifically examined how military consumers are affected in this marketplace. We learned about benefits that you guys provide to consumers. Dealers often assist customers by providing or arranging for financing and obtaining competing offers from different financing sources. We've heard and we agree that the vast majority of industry members are straight shooters. They take pride in helping their customers get the best deal and ensuring their customers come back to them when they're ready to buy another car. But we also heard about some practices in this area that raise concerns. And this, I'm sure you've been following this debate, and it shouldn't be news to you, but I just wanted to outline what the issues we're thinking about as we review the comments. First, basic misrepresentations. Some dealers advertise a low rate or no money down, but it turns out that the terms aren't available, or there's additional fees that haven't been disclosed in the advertising. Most dealers don't do this, but when it happens, it's injurious to consumers, and it brings everybody down. Everyone, I think, when we discuss this, agrees these practices shouldn't be tolerated, and at least the FTC should be bringing enforcement under its existing authority, which against unfair or deceptive acts or practices. Second, there's concern about add-ons that consumers don't understand. It's kind of related to the misreps, but not always. By add-ons, I'm referring to features that are not installed by the manufacturers, but are installed by the dealers, whether it be warranties, rust-proofing, GPS, security devices, insurance, et cetera. Many dealers provide information to consumers about add-ons and give consumers the opportunity to decide about them, and information about whether they're optional or required. But some don't make it clear when quoting a price that, whether add-ons are included and whether consumers have choices about that. And that's a problem for consumers trying to compare offers, and perhaps going to the dealer that makes the best offer. Third, we've heard a lot about dealer participation and dealer markups, whatever you want to call it, the rate by which dealers mark up the buy rate from the lender prior to offering it to consumers. This is a very controversial issue. It's hotly debated at our workshops, lots of articles about it. An article just in, I don't remember which paper, the Wall Street Journal, was it this morning? About the CFPB looking into this. Not for auto dealers, but for the financing companies. They don't have jurisdiction over most auto dealers. I want to remind you of that. The industry members said at our workshops and to us separately, dealers perform many services in relation to financing. They compile the documentation, they shop the deal around, they prepare documents, they execute various forms. Shouldn't they get paid for this? Consumer groups said that the amount of markups varies between for consumers. It's not a set increase on the wholesale rate. It's not visible to consumers. Only sophisticated consumers may realize they can negotiate it, so it ends up affecting the least sophisticated. And they said this discretion also makes discrimination possible. And there have been cases in the past related to dealer markups and discrimination. So this is a big issue that everyone is debating and we're looking at. Fourth is this issue of so-called yo-yo financing, where a consumer buys a car with one rate and then later is told the rate went up. Sometimes the consumer's trade-in is already sold and the consumer needs to get to work every day or take his kid to school. So he agrees to the deal, even though it may not be a good deal for him. Or he's told he can unwind the deal, but there's lots of fees because he used the car. We understand most spot deliveries which many consumers may think is a benefit that they can write off in their car, are agreed to on the terms submitted, and that most dealers have incentives to avoid this situation. But when it happens, consumers may be forced to accept a deal that's not good for them and forego better deals from more honest dealers down the road. We're concerned about this practice, and we're looking at that. And finally, there was a lot of discussion and concern about how all these practices affect military consumers. The San Antonio Roundtable was specifically devoted to that issue. The servicemen are a very vulnerable group because they tend to be young and inexperienced, and yet they're in possession of a steady paycheck, often for the first time. Some dealers have taken advantage of this experience, making misreps about the terms of financing, falsifying loan documents, not disclosing expensive add-ons, engaging in other troubling practices like the ones I just described. There's particular dealers that cropped up around military bases that I know one of you had a quote in the paper the other day saying NIADA is concerned about that. Did I pronounce that right? Is it NIADA. You never say the NI because it doesn't sound good?
We could start something new. I
learned something. NIADA doesn't sound so good. I don't want to say that anymore. Yo-yo financing is also a particular concern for military servicemen because they move around and they may to leave the area before financing is finalized. So those are the main issues. I'm sure there are lots of others, little ones that were discussed, but they cluster in those main issues. We're still considering what to do with our new authority. Nothing has been decided. We're still studying the issues as we should do. Some stakeholders are saying very strongly the FTC should propose a rule to set clear standards, separating the good practices from the bad, to provide clear sanctions. Others, including industry, you guys, say that the practices are an exception in the industry and that the FTC can use its existing authority to address them. Both positions have some validity, and they're not entirely at odds. We want to emphasize that anything we would do in this area, both in terms of enforcement of existing laws and if we were to develop a rule, would focus on the bad actors and would be designed not to impose burdens on legitimate players, again, to level the playing field. In the meantime, we are using our existing authority to tackle these types of practices. It's again, unfairness and deception to address problems in the marketplace. I just want to mention a few cases we brought in March We brought what we are calling the negative equity cases, and it created a stir, apparently. It was 5 settlements against companies that promised, we'll pay off your trade no matter how much you owe. The consumers were deceived into thinking the dealer would pay off their loan balance even if it exceeded the trade-in's value. In fact, the negative equity was rolled into the new loan. One dealer even required the consumer to pay out of pocket the difference. We allege that was deceptive practice because they didn't pay off the trade no matter how much you owe. We also, in kind of not directly related to you guys, but enough, we brought some auto loan mod cases in April. Consumers had promised to reduce consumers' monthly auto payments by up to 40%, which was, and they charged fees of up to $800. And they also promised refunds if they're not if this refinancing, reduction wasn't successful. And what do you think happened? Once the fees were collected, they did nothing, and they didn't give the refunds. And they told the consumers to stop paying the lenders, so some consumers had their cars repossessed. I mean, this wasn't you doing it, but this affects your industry, and it's important to know about. We've obtained preliminary case relief in these cases, and we're litigating them. And we have more cases like this in the pipeline, singling out the bad actors in this area. As I also think you know, we have activity underway on the used car rule, which specifically affects this group. And I know you're very interested in that. This rule is administered out of our Chicago office. Some of you may have met Steve Baker, who heads that up, so I'm not an expert on it, but I boned up before coming here. I know there's a lot of concern about the topic of vehicle history. That seemed to be the main concern in our comments. The reliability of that history, who's responsible for providing that information. I've also talked to Sean about this. This is an area where the market has changed considerably since the rule was issued in the 1980s, when there was a particular scheme put in the rule on this for that and may not be working anymore. We're reviewing the rule now, and it should be pretty soon that we do something on this and come out with something. So, and then Sean asked me to address briefly the risk-based pricing rule because a big decision just came out in that area. We recently won a case that NIADA brought against the FTC about this rule. In brief, the rule requires anyone that uses a consumer report to provide consumers whenever a report is used in a decision to provide to provide notice to consumers when a report, sorry, it's so long, when a report is used to provide decisions about credit to consumers at materially less favorable terms than the credit available to substantial proportion of the consumers being offered credit. As an alternative, because that can be burdensome to calculate all of that and do the notice, anyone using, so this applies to dealers, and so if you give a rate at materially less favorable terms than to one consumer than another, you need to provide them with this notice. But because that may be burdensome, an alternative is you can just provide all consumers with a disclosure of their credit score. Those are 2 alternatives. The goal is to ensure that consumers know about potentially negative information in their credit report so they can check it and correct accuracies. The law had previously required notice to consumers only when there was adverse action, meaning a consumer was denied. But with the rise of risk-based pricing, Congress passed this new requirement, and it applies to everybody that uses consumer reports for this purpose. After issuance of the rule, NIADA argued that dealers do not use credit reports because third parties, the financiers you're working with, actually obtain the consumer report, but the court disagreed. FTC and agreed with the FTC's reasoning in this area. The FTC had said that a dealer that doesn't obtain consumer reports nonetheless uses it when a dealer executes a credit contract based on third-party financing. Dealers are the initial creditor in the third-party transaction. Dealers are the person the consumer is dealing with and knows. It would be very difficult to impose the requirement on the financing company because there may be multiple notices and it really doesn't make sense. And the court agreed with the FTC's arguments, meaning that dealers will need to make sure consumers get notices when they get material less favorable terms, or as an alternative, provide that credit score disclosure to everybody. And if people want to know more about this, there are people back at the FTC who know more about the details of this than I do, and I can give you their names. So I've already probably taken up too much time.
Not at all.
I can address other issues in Q&A, and I'm dying to hear what questions you have. In closing, I just want to emphasize the theme of this session is leveling the playing field, targeting on the bad practices, which could help the good players in this field do their business the way they want to do it. Our efforts are designed to help consumers in a way that preserves the benefit the industry offers while targeting the bad actors. And I'll be happy to answer questions later.
All right, thank you, Jessica. We appreciate that very much. Bill?
Sean, thank you very much, and really appreciate the invitation here today. It's an honor to address you. It's great being up here with Jessica, our new colleague working in the auto area, and with your new president, who probably is the only presidential candidate who's not been in Iowa recently. And they're still coming, even though our caucuses is over. It's quite something. Wanted to give you just a little bit more about my background. I've been with the Iowa Attorney General's office in the Consumer Protection Division 25 years in a couple of weeks, which is hard for me to believe. And I've been the director of that division for the last 17 years. And for the last 8 or so years, I founded and am the chair of the NAG Autos Working Group, which is a group of representatives from approximately 35 states, territories. We have representatives from the Federal Trade Commission and the Consumer Financial Protection Bureau now joining us as well on monthly calls where we talk about cases, we talk about practices, rulemaking, federal and state legislation. We just share ideas about what's happening out there, and all with a goal of using our resources most effectively. And that's really the important thing about our work, is to try to hone in on the conduct that really is the most deceptive, the most harmful to consumers, because we know that the primary impact of good consumer protection law enforcement is a fair and competitive marketplace. The dealers who advertise and represent pricing and products truthfully lose out to those who do not. We understand that. I also understand that just about everybody in this room is somebody who's going to play by the rules. You wouldn't be here. You're here to learn about those rules and to find out what we're doing and how you can do your job well. And that is so much appreciated by us who've done this for a long time. And we've worked with the Federal Trade Commission for a very long time. I think one of my first encounters with the FTC was a used car rule compliance suite back in the late 1980s with the Chicago Regional Office, but we also worked on auto lease advertising cases in the mid-1990s having to do with the auto manufacturer leasing wings and their advertising primarily on television of no money down when in fact you did have to make down payments of payments in advance and security deposits and so on. And through that joint activity, those ads are gone now, although we still have some problems in that area. As far as the independent auto dealers, I think the best relationship that I've had in my 25 years in the Iowa Attorney General's office with any business group has been with the Iowa Independent Auto Dealers Association. We talk all the time. We exchange emails all the time. If the week goes by when we don't have a communication, it's because somebody's on vacation. But it's a great relationship, and we have a great relationship with them on issues, on legislation at the state level, and we talk about federal legislation as well. And I think that's something also to keep in mind. Your state attorney general is a player not just within your state, but also across state lines, working on congressional legislation. I've testified numerous times before Congress on federal legislation affecting auto practices, whether it's auto leasing, salvage cars, auto disclosures, and I'm a member of the U.S. Department of Justice, Bureau of Justice Assistance advisory board on the National Motor Vehicle Title Information System. Represent the state AGs, and on that board are representatives from a variety of groups, and I believe NIADA is going to be represented on that board too, and we welcome your participation. That's just great. The role of state attorney general. We enforce state and federal consumer protection laws. There are a variety of federal consumer protection laws that we can enforce, and Dodd-Frank has expanded that now. The direct ability to enforce the Truth in Lending Act, which we did not have before. We also take complaints from the public. We do not represent individual consumers like a private attorney does. We represent the state in everything that we do. But consumer complaints are our best source of information about what's happening in the marketplace. We propose laws and we lobby the legislature. A number of us, including our office, can adopt rules akin to the Federal Trade Commission. And these rules go beyond the law and interpret the laws. In Iowa, it's the consumer fraud law and our authority to define what practices are deceptive and misleading. And then the question before a court when we enforce that rule is, was the rule complied with? What was the conduct, not whether engaging in that conduct violated the law. The rule establishes that it violated the law. Takes that decision away from the judge. We don't have a lot of rules in the area. Some states have quite a few, particularly automobile advertising has been a big source of attention. And we work with the public very frequently with business groups like NIADA and the Iowa Independent Auto Dealers and others to try to come up with common sense proposals that protect the public without, as Jessica said, unduly hampering businesses. Our job is to try to make sure that competition is vigorous and fair. That's what we're there to do. The automobile area, of course, has been an area of top complaints, and everybody knows that. It has for a very long time, ever since I've been in the office and before, well before. And what I'd like to talk about today is some of the problems that we've had in the used dealer market, and also some that really cut across lines and address both new and used dealers. In the used dealer area, in Iowa specifically, we are having some concerns with compliance with some fairly simple laws, like the Truth in Lending Act. We're seeing dealers who are advertising 0% interest, when in fact they are imposing fees that relate to credit. Somebody who's paying over time pays a fee that somebody who pays cash doesn't pay. That's an interest charge. That's a finance charge. And in some instances, we're seeing these charges and not only being misrepresented as being 0%, but when you calculate them out and determine what that rate really is, it exceeds the state usury cap on automobile loans. So we're requiring refunds and changes in practice. And it's been a successful program. We've been doing several dealers over the past year or so. These shops tend to be primarily smaller shops. I doubt that many of you would be engaged in that conduct, but it is out there. And consumers are being overcharged, thousands, literally. We're taking a look at situations involving lease to own. We had a law that we proposed several years ago under our rent-to-own law that eliminated the possibility of selling a vehicle through a rent-to-own transaction. Our concern was that we've got a regulatory scheme out there for vehicle financing, and it made sense. And by using rent-to-own, dealers were able to get around repossession laws, limits on interest, and so on. We didn't think that was right, and so we, in essence, worked with the legislature and the governor to get that banned. But now we see an attempt to go around that the last couple of years by structuring it as a lease-to-own provision, and doing that by having payments greater than 5, I believe, which brings it out from under the rent-to-own provision. And that concerns us a great deal because, once again, we're seeing that consumers' rights against repossession, a right to get a 20-day notice of right to cure, are being avoided because of the structuring of the transaction in this way. We think that's inherently unfair. It's not what was intended by our legislature at all. We continue, after all these years, to have problems with vehicles being sold without disclosure that they are prior damaged vehicles, prior salvage vehicles, prior flood vehicles, and given the amount of information that's out there through NIADA, through Carfax, through AutoCheck, and otherwise, it surprises us that that continues to be a problem, but it is. And California is dealing with that right now with their new law going into effect that requires an NIADA search be run whenever a dealer is selling a vehicle. I'm not here to endorse that, even though I'm on the NIADA's board. That's California's decision. What I care about is that the disclosures be made, that they be accurate. We're even seeing situations, for example, we have a law in Iowa that requires that if the vehicle has been damaged over 50% of its market value before it became damaged, you have to issue a written disclosure. It's basically on the same form, in essence, as the odometer statement on the back of the title. Now, we'll see pretty significant damage just up to the line, or maybe 25%, 30%. And although the disclosure is correct, no on the form, consumers will come to us and say, well, geez, this thing had significant damage. I'm trying to trade it in, and they're telling me, even though they checked no on the box, this prior dealer, these dealers on trade-in, they won't give me value for it because they can find reference in Carfax or whatever to this prior damage. And that's right. It is worth less. And that dealer that sold them the vehicle and didn't disclose it, while they technically complied with our damage disclosure law, we have a legal argument that they violated our consumer fraud law, that what they did was deceptive. And we also have a provision in our law that says you cannot omit to disclose material facts with intent that others rely on the omission. So we can have that argument. And that's a difficult one for us sometimes, because you have this specific law out there and the general law and how they mesh. Courts in Iowa have not come down on that yet, so we don't know what's going to happen there. Sometimes dealers will respond to a complaint by saying, well, I sold it as is. So, so what if they're complaining about this past damage? I sold it as is. And our response is, legally, that's not a defense. That's a defense as to whether there's a warranty. It's not a defense to a consumer fraud claim. You can't say, I'm going to conceal all this damage as is, buyer beware. It's not how it works, and it hasn't worked that way in most states for a very, very long time. So it's important that dealers understand that. There's an obligation there to share information to make sure the marketplace operates fairly. And I think most dealers don't want to sell cars that are worth less in the marketplace than as represented, or that could be safety problems for people. So that continues to be a problem, though. We're seeing some advertising by dealers that they're going to repair consumers' credit if they buy with them. And sometimes that might be a buy here, pay here dealer. It might be the kind of dealer where you go in and they find the one car for you. They don't have prices posted on their cars, and then they say, well, you go out and you buy that car, and you may be paying much, much more for that car than the average retail. It might be double or up to double. But it turns out the dealer doesn't even do a credit report. They don't even contact the credit reporting agency about these deals. They're not repairing anybody's credit. That's just a flat-out false claim. We have a number of problems that states are dealing with when dealers go out of business, too. And we hope that doesn't happen to any of you. But unfortunately, with the economy being what it's been in the past 6 years or so, we've had a good number of dealerships that have gone out of business. And when that happens, on occasion, we will have an array of problems that we have to help clean up because nobody else will do it. And you have dealers who have sold service contracts to consumers. They've collected the money, but the money hasn't made its way to the service contract provider. It's in the consumer's loan that they have to continue to pay. They haven't paid off the trade-in for the consumer's trade-in vehicle, the loan on the trade-in. And so the consumer's paying on 2 cars. Maybe they didn't send the money to the state for tax, title, and license. and the consumer didn't get their trade-in loan paid off either. So they're paying on 2 cars and can't legally drive either. One's gone, the other one's sitting in the driveway, and they can't title it unless they pay out of their pocket again. So there's some real serious problems there. And it takes a lot of resources at the state AG level and state departments of motor vehicles and transportation to deal with these, to try to find the paperwork and figure out where things stand, and then to make claims on dealer bonds or the kind of funds that some states like California have to cover these kinds of circumstances. Finally, I wanted to talk a little bit about a buy here, pay here practice that involves GPS, which is something that Jessica mentioned, and the auto-disabling devices. We have those in Iowa, and we have not taken the position that they are unlawful. There's no specific state law on them, and we know dealers are using them. And actually dealers and companies that wanted to sell the shut-off devices came to us before beginning to use them in Iowa and talked to us about the lawfulness of using them. Now, what we said was, under our consumer credit laws, if you are using this device to disable the vehicle, that is an attempt to collect a debt. And it triggered a variety of laws. First of all, the consumer has to be in default. So they have to be, in Iowa, they have to have missed a payment and have not made that payment for 10 days beyond the due date of the payment. In addition, they have a 20-day notice of right to cure under our law and under a variety of laws out there in other states as well. There's a cure period. That also has to be complied with before this device can disable the vehicle. In addition, the consumer has to get very prominent and clear information about this at the time of the transaction so they understand what's going to happen. All these things are important, and we also, of course, understand that GPS is being used to track the vehicles as well. It's the same situation. There has to be very clear and prominent disclosure to the consumer up front that this is happening. This is a material fact. It is something that a consumer would want to know in making a decision whether to purchase the vehicle and how much to pay for it, the fact that this is going to happen. Some consumers are going to be very concerned about their privacy, and they may say, I don't want to buy from a dealer that does this. I want to go elsewhere. That makes it material, and therefore it needs to be disclosed to people. Now, there's no specific form for doing that. There's no odometer statement for doing that. But do disclose it. Do it in writing. Have the consumer sign it. That's always the best advice whenever there's a material fact out there. Keep a copy for yourself and give a copy to the consumer. Then you have evidence you can use if they come back and they say, they didn't disclose that to me. Well, sure you did. Here it is. So those are key things in the used car area, used dealer area that I wanted to talk about. And then there are a few practices that cut across both new and used dealers. One of them involves conduct in connection with credit that has concerned us for a long time, and we're certainly hoping it's not very widespread, but this kind of conduct was widespread in the context of mortgage loans and is one of the reasons why we had the mortgage crash that we did, and that is false credit applications. We have seen an increase in this again in the auto area of misstating consumers' income, inflating their income, calling a part-time job, which was temporary, a full-time job, inflating the down payment beyond what the consumer actually was making as a down payment, inflating trade-in values, underreporting amounts owed on trade-ins. All of this conduct was combined in a recent complaint that we dealt with involving a new motor vehicle that actually wasn't new. It was a relatively new used vehicle sold by a new dealer. And a young man named Austin, who was 20 years old, purchased this vehicle. He's mildly autistic. It was actually the third vehicle he'd purchased in about 2 years. His parents were very concerned. They now have power of attorney and the ability to manage his financial affairs. He no longer has that. But what happened was they went to this dealership, and there were 3 credit applications prepared. The first 2 went to financial institutions unrelated to automobile manufacturers, and it had inflated income. It had him living at home when in fact he was living on his own. He actually had just a summer job that was temporary. It was connection with some schooling he was receiving, and it was put down as a permanent job. Even with that false information, those 2 credit applications were denied. And then the dealer included more false information on top of that in an application to Ford Motor Credit, which then granted the loan. The young man brought the vehicle home, and his parents were outraged. Now, he was living on his own with a buddy at that point. He brought the vehicle to his parents' house. They were outraged at what happened. They contacted the dealer the very next day, brought the vehicle back, and the dealer said, listen, he's an adult. He can sign this contract. He's purchased cars before. We know him. He gave us all this information, and we're not going to take it back. Parents left the vehicle there. The vehicle was treated then as a voluntary repo. Ford Motor Credit sold the vehicle, repossession, auction, and there was a $9,000 deficiency. The parents filed a complaint with us, and we went to work on it, subpoenaed the records from the lenders and from Ford Motor Credit, got those records, looked at them, could tell that there were a variety of falsehoods there. The dealer blamed the young man, said he'd given the information, wasn't their fault, it was wrong. In any event, we went to Ford Motor Credit and said, no matter who you believe here, you issued a loan based on false information. He's not working. That job was over. That job was not intended to be a permanent job. And all this other information was wrong, just flat out wrong. Ford Motor Credit ultimately agreed just recently and waived the deficiency and are cleaning up his credit reports. Of course, he got a negative credit report about this. And in addition, the young man and his family have sued the dealer. So our role was to try to do what we could to help him, and that was to get that credit cleaned up and get the deficiency waived, and now he's got a private attorney bringing a private action. That's one example, and a pretty extreme example. But we have seen this more recently grow, and it's a really bad practice. And we're going to keep our eyes on it. And of course, if we find this dealer continuing to do it, then we'll bring an action that will not just be for this individual, but for all affected Iowa consumers going back a period of years. So it's one of those situations that's unfortunate, but we're very glad that this young man and his family brought it to our attention. Another area that cuts across is advertising that the dealer will accept all credit applications or will process all credit applications, with the deceptive implication that they're going to approve all credit applications, which of course is not true. Very, very seldom would that ever be true. And that's been around for a while. Again, it's a conduct that we're seeing grow. We're also concerned about situations, and these are less frequent, where the dealer tells the consumer, we got you the best rate we could. It's the best we could find, when in fact there is a yield spread premium, and they're not telling the consumer that it's not really the rate they found for the consumer, it's the rate plus. That's just a flat-out misrepresentation, and that's what concerns us. We're not taking the position in Iowa that yield spread premiums have to be disclosed. I think that there are some consumer advocates, private attorneys out there who wish we would be more aggressive in that area. We've not taken that position, but we are concerned about deception in that context. Finally, we are concerned about what I call false premise advertising. And this also is something that goes back several years, but became prevalent about 10 years ago and has continued on. And that is, and these are primarily new dealers, but sometimes big used dealers do this as well. They do business with an ad agency, and it's not the kind of ad agency that most folks are used to thinking about. It's maybe operated by one or two individuals who have these ad packages that are designed to sell a used inventory, and they make it appear as if the vehicles are coming from some other source that's trucking them in just for a single event. that they are not the standard inventory that's been on the dealer's lot for weeks. Very often they hire third-party sales teams to come in and supplant the dealer teams. And some of the conduct that we have seen by these third-party sales teams hired by these ad agencies, just outrageous stuff. Taking keys away from people on their trade-ins, and just horrible misrepresentations about the vehicles and about the financing. It's a conduct that really concerns us. And then the advertising itself concerns us as well. Often mail flyers that go out to people, telling them they've won a prize, when in fact everybody gets the same prize, which violates our prize promotion law in Iowa. It's a Consumer Fraud Act violation to do that in Iowa. Mailing out keys, says if it matches, you win a car. Not telling people that that same contest was mailed to scores of dealers, or by scores of dealers around the country. And in fact, there's only one winner in the whole country of the whole thing, and seldom does anybody ever win. Those ads have really concerned us. The state attorneys general joined together and brought out successful action against one company a number of years ago called Gunning & Associates. We also have pursued others and will continue to do so. In Iowa, we're preparing a lawsuit right now against one of the companies and also against the dealer in Iowa that was heavily using that company because of the deceptive nature of the advertising primarily. And we will see where that goes. Finally, I wanted to just talk a little bit about what to do if a complaint comes to you from the state attorney general. They've received a complaint, and the standard practice of state AGs, or in Georgia, for example, the governor's office of consumer affairs is the entity that handles the complaints. Make a copy of it, send it to the complaint against party, and ask them to respond in writing. Our job is not to prejudge that complaint. We want to hear both sides. When you do respond, send copies of materials from the deal jacket that support your point of view. Send everything so that we can take a look at it and try to make an independent evaluation of our own about what happened. Now, in most instances, we're going to try to work with the parties to resolve the situation. Sometimes, though, that complaint gives us a notion that perhaps there's a problem there, and it may result in the issuance of a civil subpoena down the line. But the bottom line is, it's in everybody's interest to try to cooperate, work together, respond as well as you can, and we'll try to work with you. I don't think you'll find state AGs being unfair. I hope not. We try to be fair to everybody, consumers and business, and to not waste our resources on situations that don't involve fraud, unless there's some way we can help the parties resolve a dispute beyond that. I talked a long time. I appreciate your attention. Thank you.
Bill, thank you very much. Bill, I thought I might ask you to speak a little bit about the letter that the Attorney General's sent in response to the roundtables about spot delivery. And then Jessica, if you wouldn't mind talking a little bit about spot delivery from your perspective in response to that letter.
Yeah, it was the number one issue in the state AG's letter to the FTC following it on the roundtables. And we really, really appreciated the ability to have input on this. And I think the commission is going about this just the right way. They're getting input from every interested party and trying to use that enhanced authority, shall we say, in a responsible way. And that conduct of spot delivery that morphs into what we call a yo-yo sale is so blatantly unfair that it really came up among the state attorneys general as being a number one concern. The notion that you are going to say to the consumer, we're going to send you out, we don't have financing arranged yet for you, but here's the deal and here's what we're trying to get. And then the consumer's out there, and 2 weeks later they're told, bring it back, bring that car back. We couldn't get you financed under the terms that we had there. Now, we do have a deal here, though. You either got to take this or else you're going to lose your trade-in because we sold it. So here's the new deal. The interest rate is 3% higher, and you're going to have to make more payments now. It's 72 months instead of 60 months. You already have, I think, somewhat of an imbalance in negotiating at the outset, but when this happens, you have the consumer over a barrel. they really don't have an option. The trade-in's gone. They're told, you've got to accept this deal or you are defaulting on a loan. It is really not a good situation. Now, there are some states that have laws about this that require disclosures up front to consumers, that require the dealers to hang on to the trade-ins. And what we were urging the FTC to do was take a look at this practice and consider some rulemaking that would be a real solid baseline of protection for consumers so that nationwide, this would be something, the process of dealing with this would be something that dealers could count on being the same, except for those states that are more protective, and something consumers could count on as well, so that this does not continue. We don't see it as frequently with used dealers as we do with new dealers, and I'll just be blunt about that. But it is, you know, it was the #1 concern for state attorneys general, and we've been doing this work a very long time, and this is one of our top complaint areas. So we really have appreciated the attention the Commission's given to it. We understand, I think the NADA was most vocal in arguing that there should not be regulation, but there just should be a case-by-case process on it. I think having a baseline of protection is good for business because it's predictable. It gives you predictability and it gives you protection if things go wrong, if you do things the right way.
So we're very much looking at this issue, and we take it very seriously, and I did appreciate the NAG's comments. What we're looking, you know, if we do some rulemaking in this area, we're looking at how to do it, as I said, in a way that preserves some of the benefits, or the many benefits but targets the bad practices. So, you know, many consumer groups have urged us to outlaw spot delivery. And we're looking at options that don't do that because we think there are many people that may view spot delivery as a benefit, consumers. But meanwhile, you have, I think Bill used a phrase, spots turn into, they morph into a yo-yo, and what can you do to arrest that process? So, you know, one thing consumers may not understand is that when they're given a deal, it's not final. And I think most consumers, when they drive away, they think that deal is final. So is there some way to educate consumers that it isn't? If a spot situation arises, what can be done to arrest that and equalize the playing field, this time for consumers? Can you put some limits on what happens to a trade-in while a deal isn't final? Can you give consumers the option, real options of declining that don't involve enormous charges? So we are looking at this issue, but we are looking at various alternatives, and this would apply to how we would enforce it too. So does not mean we've made any decisions about any rulemakings, but we're looking at how to stop that spot from turning into a yo-yo rather than going to the to what has been proposed of completely outlawing spot delivery.
Yeah, and state attorneys general did not necessarily agree with the consumer groups that outlawing spot delivery was the way to go.
Right.
But the key thing for us is for consumers, if things don't work out, if the original financing deal cannot be honored, consumers should be able to say, okay, I don't want to go through with this now. This is not acceptable to me. I will bring the car back, give me my trade-in back, and let's call it a wash. And that's the way it ought to work.
Exactly, and without high fees too.
Without fees, yeah.
So I know that the letter had some, kind of recommended best practices, or at least suggestions to the FTC that may morph into best practices.
Sure,
Would you might
Yeah,
address
first
a
of
couple
all,
those?
retain the trade-in. Absolutely, retain the trade-in. Make it very clear in writing to the consumer that the deal is not final, just what Jessica just said. Certainly the truth in lending disclosures have to be there about the loan that's been applied for, so the terms should be very clear that are being applied for. don't impose fees on the dealer or on the consumer if the vehicle has to be brought back. There have been some dealers that have charged so many cents per mile that the vehicle was driven and things like that. That's not appropriate. We would like to see insurance be maintained on the vehicle, but if the original financing deal cannot be honored and the terms are not beneficial for consumers, terms the consumer does not agree with, and the subsequent loan that's been obtained, then the consumer should have an absolute right to decide either to accept those terms or to say, no, the deal is off. I will bring you the vehicle back. We also have had situations where we have seen dealers calling the police on consumers who haven't returned vehicles, saying they have stolen the vehicles. We would like the rules to say you don't do that. That's inherently unfair to do that. The vehicle has not been stolen. This is a dispute about a contract. It is not a theft. And that was another concern we've had because we've seen it.
Jessica, anything to add to that?
That was consistent with what I was saying before. Again, we're still considering the issue, though, and have not made any determination to put this kind of thing in a rule.
One of the things that we've gotten some word of are subpoenas that have gone out from the FTC on issues related to spot delivery, obviously without disclosing confidential information of recipients of those subpoenas. I'm just kind of curious if you could give the audience a sense of the types of information that the FTC is looking for in those subpoenas, in case one of these dealers happens to get it, how they could respond to it, and what steps they would need to take to appropriately respond.
Well, I can't comment on non-public investigations, and of course, I would urge all dealers, if they get a letter from the FTC or from any state AG, to be as cooperative as possible, because many investigations do not end up as cases, and the best way to resolve an FTC inquiry, which is at the point of inquiry only an inquiry, is to just cooperate. It'll cost a lot less money if you just provide the information and cooperate than if you end up, the FTC has to enforce or ask for additional information. The types of things we would be looking at in investigating spot delivery would be exactly the facts that go along with the situation we were just describing about how a spot morphs into a yo-yo. So we would be looking at the original, the original terms offered, any written material along those lines, and unfortunately many dealers don't retain that, but it's in everyone's interest that they do, because otherwise we may just have to take the consumer's word for it, what was offered. And then the later deal that was offered and any paperwork in connection with that, any fees imposed for usage of the car, all of the things that go along with the spot delivery morphing into a yo-yo. Would just be trying to tell the story.
Great, thank you. One of the things that this group is certainly watching with great interest is the relationship, and Jessica mentioned this a little bit, between the CFPB and the FTC. Bill, I know that there's been some MOUs between the CFPB and the states. I thought maybe you could address that from your perspective a little bit. And then Jessica, if there's anything in particular that you see coming as a result of the relationship that you have with CFPB, I think we'd be interested to hear what that might look like.
Okay. Yeah, as I mentioned, the NAG Autos Working Group has representatives from the FTC and CFPB on there, and while CFPB does not have direct jurisdiction over auto dealer conduct, if there is a buy here, pay here situation, they do. A dealer that is basically financing purchases is covered by CFPB as well as FTC. And Iowa has signed the memorandum of understanding, but with the CFPB, but be that as it may, I mean, we'd be working with them anyway, just as we've worked with the FTC. And it's only natural that agencies are sharing information that have overlapping jurisdiction. And, we want to make sure to do things efficiently and to work together in cases together where that makes sense, and also to share our investigative resources where that makes sense. CFPB may have some financial experts that help all of us. FTC may have litigation experience that helps all of us. So it's very much of a team effort, and I look forward to continuing in that kind of approach. But we share information and share ideas and try to do the best job we can for our constituents.
So we entered into an MOU with the CFPB. I think it was one of their first because of there's an enormous amount of overlap between the CFPB mission and the FTC mission in January. And we are coordinating on a daily basis with the CFPB, and it's going well. That being said, we've given a lot of thought at the FTC to what areas make sense for us to continue to take the lead in, because the CFPB does have a vast jurisdiction. It does have some powers we don't have, like examination authority. So we want to do what is best. We want to be as efficient as possible by focusing on areas we think we can really make a difference. And I mentioned the 5 areas we're focusing on, and that really reflects a lot of thought to where we can continue to be leaders. It's auto, obviously, because we have greater authority than the CFPB does in that area, although we're coordinating there too. It's payday lending, it's mortgage and debt relief, it's mobile payments and other use of mobile in the financial area, and debt collection, where we've provided a lot of leadership. Similarly, I'm not in the privacy division anymore, but there's overlap in the Fair Credit Reporting Act and in GLB, and there's a lot of dialogue in those areas. As Bill said, it's just good government to be coordinating, but we do also have processes in place that help us along the way. And we continue to coordinate with the states, and we don't have an MOU with the states, but we've always had a very good relationship with them.
Absolutely. Yeah, and there are several other agencies out there at the federal level that the states work with. The Department of Justice, criminal prosecutions for odometer fraud, and actions relating to noncompliance with NIADA regulations. We work with postal authorities all the time. National Highway Traffic Safety on vehicle recalls. We're very frequently working with them. So we have a lot of valued relationships at the federal level, and I think it's a good team effort all the way across.
But we are waiting to see what happens. The CFPB has a broad mandate, and it's got rulemaking, it's got studies, it's got enforcement. They haven't brought a single enforcement case yet. They've been busy with churning out proposed rules, et cetera. So depending on what kind of energy they put into their enforcement, we'll adapt and continue to think about what makes sense to us for us to keep plugging our resources into.
Speaking of CFPB rulemaking, there in studies, the study that the CFPB is proposing on arbitration agreements. Bill, I wondered if the states had any interest or talking about that at all, and what comments they might provide with respect to that request.
Well, state attorneys general have been concerned for years that consumers are denied justice. If there is a form agreement there, some language in what we think of as basically a contract of adhesion saying this is going to be governed by arbitration. And so consumers go online and they buy something, and buried online in the terms and conditions that nobody ever reads, including lawyers with 50 years of experience, is a little line that says you're subject to arbitration, you have no right to go to court, you have no right to class action, that sort of thing. While it's something we haven't seen as frequently in the automobile area, I'm sure it's there, and it's a real concern for us. So I think we're going to strongly advocate for consumers to continue to be able to have their rights to access the judicial system and not be forced into arbitration. We have not made any official comments as of yet, and I don't want to speak with a broad brush and say that's going to be the position of every state attorney general, because it might not be. But pretty sure that'll be Iowa's position.
Jessica?
And I would add that, you know, we haven't taken a position that, you know, you can't do arbitration, but we have done work in the debt collection area, and in addition to the issue of whether consumers even know they're entering into an agreement to forego their, you know, rights to sue or whatever and do arbitration. Once you're in the arbitration process, you know, consumers don't get enough information to even proceed so that they know what's happening. They often don't even realize it's happening, and it ends up being done without them, type of thing. So there's a lot of issues there, not just about the initial decision about whether to go into arbitration.
Yeah, I'll add that Iowa became the 50th state in 2009 to adopt a private statutory remedy for consumer fraud. We were the only state for many years that didn't have it, and it took me 8 years to get it passed, and I'll be darned if I'm going to lose it to arbitration clauses.
Well, Chris, I've dominated the stage here. Maybe I'll throw a question out that may relate to your business. Chris is located not too far away from Fort Bragg, and Jessica, you'd mentioned one of the roundtables that specifically mentioned military-related issues. Thought maybe we might ask if there's any, you know, best practices or such, Chris, that maybe you can chime in from your perspective, but also from Bill and Jessica's perspective as it relates to interacting with the military personnel on the side of the car.
We certainly do everything we can to make sure we're doing things right with, you know, consumers, regardless whether civilian or military, but I do know that we go the extra mile as far as our military consumers are concerned. You certainly, you know, everybody's heard the nightmare scenarios. I don't believe they're predominant, just, you know, there's some isolated issues out there. Some of the things, I'll raise a situation that I actually saw for myself the other day. We had a consumer come in. She was upset, had just purchased a vehicle from a dealer, and the reason she was concerned is the dealer had quoted her $13,000 for the vehicle. When the paperwork came time to be, you know, consummated or executed, the vehicle was $16,000, and she asked, you know, what's the $3,000 for? And the dealer explained to her it was bank fee. Well, after talking with the consumer for a little bit, the dealer did agree to take the car back, but what was happening was the dealer had found that because of the consumer's credit, they were going to have to pay a $3,000 fee to the bank to get that deal bought. So they just added it onto the price of the vehicle. Well, obviously you can't do that. And I know that happens. Again, isolated instance. I've only seen that happen one time in 20 years, you know, face to face, but it did happen just the other day. But I tried to counsel her on, you know, what she could do, but she had already contacted the dealer. The dealer had already agreed to take the deal back and, you know, handle it that way. But you know, that's just a situation that I've seen. I don't know what you guys have.
Well, on that particular practice, it actually was one of the points in the Attorney General's comments to the FTC that we have seen it more frequently than that, and that is a finance charge. That's interest, number one. You know, there are some lenders out there. It used to be they'd pay the dealers. Now they're asking dealers to pay them to take the deal.
Yeah, exactly.
And you know, if that's the situation, it's kind of like a spot delivery. I mean, with a yo-yo, you go back to the consumer and you say, well, here's the situation. They're charging this amount, and you have to say, this is how much that equates to in an interest charge. Here's your TILA disclosure. Do you still want to do the deal? Sure. That's the right thing to do. You're exactly right.
Absolutely.
You're exactly right.
And again, we're fortunate in Fayetteville. Again, 20 years, I've seen that happen once. But I know things do happen like that. And
yeah, maybe Jessica wants to talk about what the input was was it San Antonio that had that?
Yeah, so we've looked a lot, and we've also had, there's a fair amount on the record in writing about dealer concerns, and you know, and we've had letters from various military organizations talking about these practices. To a large extent, many of the concerns that are surrounding auto dealer practices and military reflect the concerns for everybody. So it's yo-yo, it's, you know, it's misreps, it's tacking on fees that aren't disclosed. But the additional issues you've got for the military are that the consumer may not have established credit, so you have a situation where it's more likely to happen because they don't have credit and you have to pay an additional fee. The consumer is young and inexperienced, needs perhaps more hand-holding, more educational materials. The FTC has done a lot, and I think the states have too, efforts to educate the population and work with military organizations to educate them. So there may be special, you know, if dealers are going to plunk themselves down around military bases rather than preying on they should provide those extra services of educating them. One additional issue is that, you know, that affects yo-yo more than anything else is that people may be shipped out quickly. And so they've gotten they did their spot delivery, they drove away, and when they're called to say the rate is higher, or the spouse or whatever, whoever's in the house, the person is not there, adding to the distress created by the yo-yo situation where they can't even return the car. So those are the issues we're seeing with the military.
And one thing I'll point out as well, it's, you know, the website with the FTC is wonderful. We've had a couple of instances where, and I always call it the Soldier and Sailors Relief Act. It's the servicemen's.
I still do.
Anyway, you know what I'm talking about.
Yeah.
I know there's a new name for it, but you can, if you have a question, we have, you know, a military individual come in and want to exercise that act. You can go right on their website, pull it up, search for it, and it'll give you in a one-page synopsis exactly what you need to do to handle that service member and handle them properly. So that's, just had that happen in the last couple of months.
Yeah, there are
Thanks.
caps on the interest and loans and so on that apply
Exactly.
where you have a service member, and it's an important law.
Wonderful, thank you. Jessica, there was a recent decision, I think it was announced last week as a matter of fact, about a dealer in Georgia that had some privacy violations on peer-to-peer networking software where information was disclosed over the network to unauthorized individuals. I don't know if you're familiar with the case, if you maybe could give just a brief overview of the case, but more importantly about the issues and what the dealers might do to protect themselves from that.
So the case grew out of an initiative that actually, when I was running the privacy division, I started. So I know a lot more about the overall initiative and less about the specific case. But what we did is we learned last year, or I think it was last year, that from an expert on peer-to-peer software, that there were enormous amounts of sensitive personal information floating over the P2P network. And we conducted a bunch of non-public investigations and actually issued warning letters to many different entities that those files were associated with. And this case grew out of that. And the worst situations we actually targeted for enforcement and didn't do warning letters. And what had happened was it's very common for companies not to have firm policies in place prohibiting employees from downloading P2P software. P2P software is used to share music. It's used for all sorts of purposes. But if one of your employees downloads that software on your network, it may lead to sharing all your files because some of that software isn't designed very well and it pulls files from many different sources and then shares it over the P2P networks. So what we discovered is that hospitals and tax preparers and auto dealers and financial institutions and many different entities, this had happened. And while, you know, their employee had done it, they didn't have, you know, in situations where the organization doesn't have good policies in place to prevent this happening, and there's ways to actually configure your systems so it actually prevents P2P software from being downloaded on it. But at the very least, policy and education telling your employees not to do this. If you don't have those types of policies in place, you can be liable if one of your employees, even without your knowledge, does this. And so that's what happened in the case. We held an auto dealer liable for doing that.
Any recommendations on best practices that they might do specifically to comply with the safeguards rule and privacy rule?
Well, the safeguards rule, and it was a rule that I wrote, so it's blissfully short and easy to understand. So you should look that up, and it really provides guidance on procedures to take to develop a data security plan. And most of it's common sense. Most of it's, you know, figure out where the holes are in your system, where the risks are, and then plug them. In terms of P2P software, we have a guidance piece, which is very good, and it basically says first choice is see if your system can actually be configured so it actually won't allow somebody to install P2P software on it. And most modern systems can be done that way. But if not, you know, do training, tell your employees it's strictly forbidden at peril of disciplinary action, and then you can avoid a lot of heartaches. Because you don't want your customers' social security numbers out there on the P2P system. Once it's out there, you can't get it back.
And put password protection on your computers. I can't tell you how many dealerships I walk into where nobody's around and the computer is on and it's right there.
Right.
So, simple things like that. Folks, we want to hear from you. What questions have you got for Bill and Jessica?
Oh, a question.
Yes, sir, right there. Yeah, let's, Anthony, do you mind?
And now the lights
Joe's,
are up and we can
yeah,
see
we
who's
got-
out there.
We've got some people here on each aisle. Before we go to that, you guys were just talking about the military. One of the things, and a lot of these people out here do not know this yet, but you and I, last time I was in your office, Jessica, talked quite a bit about this. Right after convention here, we're, of course, and Bill, you may not know this, but we have 2 internet networks. One is dealer education, and the other is slanted to consumer education. And military is a big thing we're going to tackle. Good. A lot of training for the dealers on NIADA TV, and then in fact, even on the consumer section, there will be an actual military channel on there.
Excellent.
That's really excellent.
So
yeah.
that's
Good
coming.
idea.
Questions?
Okay, I've only been in business for 38 years, so I'm a little new at this. But what the heck's an MOU and a CFB, and all these other things you've been talking about?
Oh, we're so Washington or Iowan, you know, as the case may be. So an MOU is a memorandum of understanding. It's an agreement that 2 agencies or maybe countries even can enter into where, you know, that provides for, you know, all the terms they relate on. Information sharing, trading information about cases, collaborating on cases, you know, the CFPB, when they're going to be doing a rulemaking, and I'll tell you what the CFPB is in a minute, when they're going to be doing a rulemaking, lets us know. The CFPB is the Consumer Financial Protection Bureau, and it is a large new consumer protection agency that was formed last year or the year before that has a broad mandate to protect consumers in the financial area.
Okay, when you write a contract and the bank is asking for a $500 acquisition fee, or however they want to label thievery, can that be part of the contract, or does it have to be a separate document on the contract?
I don't know the answer
You're
to
talking
that
about
question.
passing that along to the consumer. Is that what you're saying?
Yes,
In the
and
consumer contract? It depends on state laws. In Iowa, it would have to be what's called a permissible additional charge under our consumer credit code. And if it's not, then it has to be included in the finance charge. So it's part of the finance charge. So if you've disclosed, you know, 9.9% interest or whatever, that may bump it up to 10.5 or something. But if you want to pass it along to the consumer, in most states, I think you can do it, but it's a question about how you do it, whether you disclose it separately or you include it as just part of the finance charge.
Okay, in no way can you make it part of the selling price?
Part of the selling price?
Yes.
You could if you had it, well, see, the deal there, though, is you'd have one selling price for credit and one selling price for cash, and that would make it a finance charge anyway. So the better approach is to, if you can do it under state law, separately disclose it in the retail installment contract, and certainly let the consumer know that that fee is going to be part of the finance deal. And if you can't, then include it in the finance charge that you disclose.
Also, if it was a $2,000 acquisition fee, is the sales tax applicable on that amount?
Again, that's a function of state law. Generally, states don't tax loans, though. They tax the underlying vehicle price and any products that come with the vehicle. So it's probably not taxable, but again, it's a function of state law.
I would like to see our Dealers Association show us in an article or something in Used Car Dealer Magazine, because I'm just a little bit fuzzy right now. The other thing that I wanted to ask about is these keys that are mailed out in mass production. I know a little bit about it, but is it legal?
There you're talking about state prize promotion laws, and you're also talking about whether in the overall context of the advertising of the sale, whether there is deception. And so in those kinds of sales that I was talking about, the reason I call them false premise sales is because there is basically a lie going on. This is not somebody coming from out of the dealership, setting up a sale of somebody else's vehicles in a lot that's not the dealer's lot. These are the dealer's inventory. They were there 2 weeks ago. They were there 4 weeks ago. This is a sale by the dealer. We've even seen them where they don't even have the dealer's name in the ad. That's bad news. That's trying to trick the public, and that's not acceptable under state consumer fraud laws. The question about mailing the key, you know, that's really a question, as I was saying, they make it appear as if only the people who are getting that mailing for that dealership are the ones that are competing. But if you look at the fine print, you find out, oh, they've been doing this all over the country, and there's only one vehicle that matches the one key in thousands and thousands of these mailings. So the chances of anybody getting it and actually using it, where it actually turns on the vehicle, are very, very slight. So we've just seen an awful lot of deception in the advertising.
Well, is there such instance where you could have a drawing on a car through your dealership?
A drawing on a car, that is really a function of state law. Usually it depends upon whether there is any consideration required of the consumer. Do they have to buy anything? Do they have to pay anything? Do they have to be present to win? There are some states that say if you have to be present to win, that is consideration, and therefore it's an illegal lottery. Could be a crime. So whatever you do, ask your attorney or an attorney for advice about that. In Iowa, you'd be contacting the AG's office and also the Department of Inspections and Appeals that regulates gambling.
Also about the advertisement of, we have hundreds of lease returns and repos and credit unions and all this kind of stuff, especially for this sale.
Again,
and it is not.
That's part of the false premise advertising. That's the kind of information that's that's the solicitation that consumers receive in the mail, or maybe it's in a newspaper. It's bogus, it's a lie, it's illegal.
Well, thank you.
Back in the back.
I have a question referring back to Chris's example. Let us suppose that the dealer had originally priced the car at $16,000 and paid a $3,000 factor. And my question is two-part, actually. A, is that if you charge the customer $16,000, pay the $3,000 acquisition fee, is that definitively undisclosed interest charge, number one? Number two, or part two, are you obligated as a dealer, or is the finance company obligated? Is anyone in the chain of the business transaction obligated to inform the client of that fee paid to the finance company?
Go ahead, Bill.
Sure. I mean, if that $16,000 price is the price that the dealer is asking for that vehicle and they would sell it to a cash customer at that price, that's the price they've been posting on the vehicle, the price they've been advertising in a radio ad or a local flyer or whatever, then that's the price, and the $3,000 is part of the dealer's overhead. But if they say, well, if you're a cash customer, you get a $3,000 discount because this thing isn't going to be applied, that's finance charge.
Over here.
Yes, thanks. I want to just thank you again for coming out. I started in the car business in 1977. As you can guess, a lot of things have changed in the car business since then, how we do business. But one thing that I think it's good to understand is the nature of a spot delivery. We've been spotting cars, I guess, for a long time. And of course, one of the things we try to do is to satisfy the consumer desire to get something done quickly. As you know, when you do something, normally a spot is done in the evening time or on weekend. And generally, when you do something at night or on the weekend, things look different in the morning. We can relate to that being in Vegas, but
They can look very different.
but my thought is that a lot of time when customers, the information you get is not exactly right, so you got to rewind the deal or call the customer back in. And the thing that when we look at it in the spot delivery is the time. The problem is called with time and distance. If it happened on a Saturday when you do the deal, of course Monday you're trying to get business done, and you find out that you need more information. So you call the customer, and unfortunately they don't respond, or it may be a week. Now they're putting miles on the car, they're putting more time. So the customer and the dealer have become over a problem there. You mentioned about sometimes the police has been called. You know, sometimes 30 days in the car, it does cause a concern as maybe the car could be stolen. So that could be one of the issues. But in the law, what should be written, it should be something explaining at what time that the car should be returned if the deal is not put together. And obviously, we do agree that within that reasonable time, the customer should be made whole with the trade-in or the down payment. But in the case that it's not done, then you get into the mileage situation because they're now using the car to plow the farm or whatever the case may be, or they're doing some things that they shouldn't be doing with the car. So that's an issue with dealers. The last thing is that I'd like to see the government being more proactive in educating consumers on the importance of good credit. One of the problems we have, I was very fortunate to get in the car business at the age of 20, so I learned the importance of good credit and bad credit and how it affects your ability to be able to handle your business and pay more because of lack of good credit. So just like we have civic and history in high school, I think there should be some type of course mandatory that a person should go through to understand credit and how credit affects their ability to be able to be a good citizen. And I think that should be what we should be working on primarily in schools and that nature. We appreciate y'all coming out. Thank you.
Thanks. I agree with virtually everything you said. I mean, so much of what you just described in the sort of spot yo-yo situation are the nuances we're struggling with. That's why both Bill and I said we would be very hesitant to support a position of completely banning spot delivery. Most spots go through and the terms offered, and sometimes the original financing does fall through, and then it's a matter of how to make sure somebody doesn't get taken advantage of on both sides. So you're struggling with all those issues. You're struggling with fees. You're struggling with the need to return the car and the need to cancel, but you also don't want to give a windfall to anybody. So all of the situations you described are what we're looking into right now and trying to strike the right balance, whether it be through enforcement of our existing laws or through a rulemaking. And financial literacy is an enormously important undertaking. We have campaigns that we do, but the FTC can only do so much. But we have an excellent website with all sorts of financial literacy materials. But anything any of us can do to help educate people on this, it's enormously important. And young people really don't understand.
Well, this is related to that. When these rules and laws are written, is there an assumption of maturity or intelligence of an average consumer? Because it seems that more and more, you're right, we're writing laws that are just down to the lowest level, where we've got to do everything for consumers. We've got to tell them everything. There's no responsibility on their part to shop and to do the way that we've always done it in the past. Is there is there an assumption of where is that level that they have to know something? They have to be responsible.
The standard that we use in FTC undertakings is the reasonable consumer. And there's been a lot of debate about that over the years. I think in earlier efforts and laws, it wasn't the reasonable consumer. It was, the most, the least sophisticated consumer. But one thing to keep in mind is that as the consumer goes about their day, they're doing a million things. So they may be a reasonable consumer, even a sophisticated consumer, but they may not be an expert in the field you're in. And you've been in it so long that you think things are so basic, but the reasonable consumer doesn't buy a car that often. And they're not going to know what you know. And so you have to remind yourself of that as you deal with consumers who may buy a car once every 6 or 7 years, if that. I don't buy a car that often, I have to tell you.
We do think about the very issues you raise as we go about our business every day. And in Iowa, I'm part of a team of folks that go through all the auto complaints every week on Friday morning. And some of the stuff we read, we just go, oh, come on now. You should have known better.
Right.
And then some of the other ones we go, whoa, what happened here? And then those are the ones that we send out. But a good number of the complaints the dealer never sees because we look at it and we go, oh, no, this just doesn't rise even to a level that we want to even check it out. So we try to be fair that way.
And I should add along those lines that one of the legal standards we enforce, our unfairness doctrine, and I won't get into that in detail, specifically requires us to prove, and we don't have to do this for all of that the practices were not reasonably avoidable by the consumer, which takes us through that very inquiry. Well, did the consumer just ignore information that was right there in front of them? Did they not take advantage of opportunities to correct the problem? So, you've put your finger on an issue that we struggle with every day.
Yeah, on the other hand, though, it's a situation where, if the response that we get to a complaint from a dealer is, well, yeah, I knew about that, but it's their fault, they should have checked too. They should have gotten the Carfax, and they should have, that's not going to go too far with us.
Yeah, well, and then the other thing is there are abuses, and we've all seen abuses, but where you penalize everybody for the abuses of some.
And
That's frustrating.
We don't want to do that.
Yeah, our goal is not to do that.
I have a follow-up question on the same topic. I think it's important to note that this is a big topic because the studies show that 85% of the consumers buy on emotion, not reason and logic. And if you stopped spot delivery throughout the country, I think you would devastate 25–30% of the jobs in the auto industry. So I think it's something that is very important to reflect on. The other thing is, we're talking about a lot of the negatives. There are positives for the consumer. Very often, we will call the consumer back and lower their rate because we got better terms for them. We spotted them on the best deal that we thought for them at the time, but often they'll come back and they'll love you for doing that. And it happens quite often in our store. So I want the positive of that to be thought of too as you're thinking of legislating a bill like that.
That's great. I'd love if somebody called me and said, hey, I have a better deal than the one we struck a few days ago. That's great.
Yeah, and I don't know if the dealer comments at any level reflected that to the commission, but that's an interesting point.
We've heard that. We've definitely heard that, and we recognize that it could go either way. The thing is, though, you want to address when it's not advantageous because, we recognize that it may be favorable sometimes, but the only thing that would need to be addressed in enforcement or rulemaking would be when it's the other way.
Correct. Thank you.
Back here.
You want me? I try to use the terms spot delivery and yo-yo deals as precisely as I can. I get my dander up a little bit when people talk about all spot deliveries as yo-yo deals, because that's it's a term that was coined by the consumer advocates to describe abusive spot deliveries. Now, I don't have any doubt. I've seen enough cases with abuses connected with spot deliveries to know that those abuses are out there. I think that most people in this room would agree that those abuses are something that should be stopped. Whether they're stopped by regulation or by enforcement is, I think, an important question. Germane to that question is, how frequent are spot deliveries accompanied with abusive features? Is the FTC or are the state AGs doing anything to determine the prevalence of abuses with spot deliveries so as to make a rational decision about whether to proceed with enforcement or whether to go with the rulemaking?
So Bill and I have very much both distinguished between spot deliveries and yo-yo, and specifically said we're doing what we can to make sure spot deliveries don't turn into yo-yo situations. So we're not equating the two at all. They're different, but they're related. And we have, part of what our whole workshop effort was about, or all of what our workshop effort was about, and all the information we're collecting is to learn more and determine what's going on out there. We don't have to prove prevalence in a technical sense in the rulemaking we would undertake, but we certainly would not want to undertake a rulemaking unless we felt it was warranted. So we are making every effort we can to look at what is going on out there and how it bears on the good practices versus the bad practices. And as I said, if we were to undertake a rulemaking in this area, we would do everything we can to surgically, as much as possible, address the bad practices without imposing undue burdens on the good. So I agree with everything you said, and I just really want to make sure you didn't hear that we were equating yo-yo with spot deliveries. We're not.
Yeah, and from the state attorney general perspective, it's not a question of numbers. We didn't count them all up. But I think we've just seen it go on for long enough that I say it violated the Popeye principle. It's all we can stands. We can't stands no more.
In Arizona, several years ago, we kind of put an end to the spot delivery dilemma that the dealer who takes that car in trade and is waiting for financing to be arranged, they have to keep that trade until the financing is finalized and until the title has been applied for. And that would be something that other states could look into.
Yeah,
Yeah.
yeah.
Anybody else out here? Okay.
Hello, my name is Molly. This is for Jessica, and this is not about spot deliveries.
We've really
If that's
touched a
okay.
nerve. Yeah.
If that's okay. We are a dealership from Boise, Idaho, and we do some buy here, pay here. I do the credit reporting. Now, what is our response? This is in reference to responding to disputes. I know that when we get a dispute from Experian, Equifax, we investigate and we respond and we verify and that sort of thing. Now, what about third-party credit repair services? We've received letters that are not from our customer. They're from Austin, Texas, as opposed to Idaho. It's not our customer's signature. What's our responsibility to respond to that?
I don't believe you have any, many credit repair services are fraudulent. So I would be very leery of them, and if there's any way to always direct your responses to the consumer reporting agencies or consumers directly, you're better off doing that. But most, if not all, credit repair outfits are fraudulent.
Okay, and then I have one more question.
Is that your experience too, Bill?
Yes.
Yeah.
Okay. So my second question with regard to all of the acronyms, FCRA, and anyway, so that letter also says, if you fail to stop reporting this, and they're referring to the Fair Credit Reporting Act and the Debt Collector Act. Now, my understanding is as a creditor who is reporting, this person's bad credit, we're not a debt collector, so that doesn't fall under our jurisdiction to respond to a threat based on
Well,
referring to a debt collector act when we're not.
they may be sending you some sort of standard letter that they're sending out to everyone. I don't know your particular circumstances, and
Talk later.
doesn't sound like you're a debt collector. Again, if this is a threatening letter from a credit repair outfit, you may want to just send it to your state AG's office. It may be.
Good idea.
Yeah.
Okay,
Yeah.
great, thank you.
Yeah, and also if you have an attorney that you work with at your dealership, you might want to show it to her or him.
Yeah.
Sounds good, thank you.
Joe?
I have two questions. First one, just to help me clear up myself, would be if a customer, normally in these dealerships, you have a generic application that the customer fills out for credit, and you send it to the bank or a couple of banks or whatever. If the customer fills out that credit application, which includes income area and job type areas, what's the dealer's responsibility as to the validity of that statement that he signed? Is there anything that comes back on the dealer if it comes out sour of that application?
In the context of the information, if the consumer falsifies it, you're saying it as part of the application for credit, it all comes down to the facts of what happened. In the case I was talking about, the dealer filled it out for the consumer and ginned up bogus information. But certainly there are situations where consumers file false credit applications themselves. And there are all kinds of potential situations there. The lender could come back on them, and the lender may attempt to hold the dealer liable, even though you didn't do anything wrong, at which point you certainly want to consult with your attorney.
Charles, one thing that I would tell you is it's important to have policies and procedures in place, underwriting being one of them. And if you're, following those policies and procedures and you've got a customer that is falsifying that information and the context of your policies and procedures, you're doing everything as you've dictated, then I think you've got a pretty good defendable position. A lot of state statutes have this idea of what we call bona fide error, that if there's some type of issue that just happens, notwithstanding your policies and procedures, typically will provide you some type of affirmative defense.
My second question is just some clarification thing. In your MOU that you have with these different agencies, does it go down and reflect the responsibilities as far as a rulemaking or a regulation that would come out of that particular area in your MOUs, or do you address that?
That's a question that we keep getting asked, is whether we divided up subject matter. And other than the specific divisions that are in the statute, like for auto dealers, we didn't. It's more of a procedural MOU to consult on everything. I think as we move forward, and I hope as somebody that's running a division and wants to do the best work, most productive, non-overlapping work in consumer protection that she can, we will evolve to sort of specializing in different areas. But for right now, we are coordinating closely with the CFPB, Consumer Financial Protection Bureau, and not so much dividing up subject matter, except in the auto area where we have primary and with the states.
Yeah, a lot of it has to do with how we handle information. When I'm working with another state attorney general's office and we're working on an investigation together, generally that's confidential. And we want to be able to maintain that same kind of level of confidentiality with the CFPB as well. And the last thing we want is the name of a company we're investigating get out there and tar that company unfairly, because it's an investigation. There's no conclusion. There's been no lawsuit filed. So we want to be able to share information without triggering application of or have disclosure requirements under state equivalents of the federal, what is that called, FOIA, which stands for Freedom of Information Act. In Iowa, it's called the Public Records Law. But that's important for us. CFPB, I believe the complaints to the CFPB from consumers are confidential. And they want us to maintain that confidentiality. Iowa's complaints are not confidential, but complaints to California are. So there's a mix out there. We want to be able to maintain that same degree of protection for the information that we have today.
And I should add that a lot of the focus of our MOU is to prevent duplication. So it has procedures making sure we're not suing the same company at the same time, or if we are, we're doing it together, and it's just one action. It's not double, coming at people from different ends. And consulting also partly to share expertise. So we have a lot of expertise at the FTC based on the work we've done so far. So when they do a rulemaking in an area that we used to be more in charge of, they need to consult with us so that we are able to provide that expertise. But the consulting also serves the function of making sure we know about what the other one is doing and don't start doing the same thing at the same time. So a lot of it is good for business, frankly, to avoid a lot of duplication.
Last question down front here.
Thanks, Mike. In Oregon, that's where I'm from, we have a different name for yo-yo financing and spot delivery. Our Department of Justice calls it bushing. I have no idea where that term comes from other than things are green in Oregon. But one thing that hasn't been touched on is the federal or the buyer's guide. Recently, and I spoke with Sean in regards to this a while back in Arlington, our Department of Justice issued an interpretation of the as-is buyer's guide. And the interpretation is that doesn't let a dealer off the hook that they've sold the car as is. And even though on the back of that buyer's guide, it clearly defines what the consumer may expect may be wrong with this. Our Department of Justice has put our dealers in a position of we're somehow a Las Vegas act in that we can predict what might happen to that vehicle. In other words, we should have known that this vehicle 4 months down the road developed an oil leak. Therefore, they're coming back and consumers are able to unwind because we should have known. And so I think there's somewhat of a disconnect between the intent, because I've been in the business for 40 years. I know what the intent of that is, and it's in the intent or the same spirit as this meeting here today, to level the playing field in that the consumers understand that, and the dealer is disclosing that this car you're buying, it may have a flat tire down the road, it may have an oil leak, it may have a transmission failure, it may have a, et cetera. So I think that the disconnect is at the federal level to the state level, and I know states can interpret things their own way, but I think that that's an issue that needs to be revisited at the federal level, and so it comes down to the states that this is what this is really intended to be, is to level the playing field and disclose to the consumer. I realize that's not something we're going to tackle right here, but it may be something that you take back and think about in communicating that to states that are now developing their own interpretations. We aren't a Las Vegas act. They're machines. Down the road, they can have problems. We've had reported to our association transactions that are over a year old that are coming back on just that the dealer should have known a year later. And that's extremely unfair. It's not a level playing field in that respect.
Well, that addresses an issue I talked about earlier, which is that, first couple of things. One, the buyer's guide being a regulation of the Federal Trade Commission does not define the consumer's rights. It is a disclosure requirement. The rights are defined by state law in that context. And so what we're talking about with the buyer's guide and as is whether under state law you are offering a warranty on that vehicle. And your answer may be no, I am selling it as is. And I don't know what the AG's basing their decision on there, but for example, we have told dealers listen, if you knew or reasonably should have known of a problem with that vehicle, like it had been in a major wreck and it had cosmetic repairs and you didn't disclose that to the consumer, that doesn't matter that you sold it as is. That's not a legal defense to a fraud claim. That's about whether there's a warranty. This is about whether you committed fraud. So I don't know what the AG is talking about there, as I'm not familiar with that. But I can take that back and ask my friend Eva Novick, the Assistant Attorney General who works in that area there in your state, and ask her, or at least pass along your comment about that you had concerns about that, and perhaps they can work to better clarify for dealers in Oregon what they're talking about there. But if you look at the buyer's guide, for example, Wisconsin has a different buyer's guide. It's been okayed by the FTC. It's got vehicle history information on it. And frankly, that was one of the things that the attorneys general in the comments that we filed with the FTC about the buyer's guide, we'd like to see the whole country have that.
My last question, if I may, it deals with diminished value. And, you know, with the information, Carfax, AutoCheck, the insurance companies are reporting these collisions. Now, these collisions, you know, the consumer is saying, okay, go repair my bumper, and the insurance company says, we're going to repair the bumper. Well, because that information is reported to these reporting agencies out there, that vehicle now has diminished value. It's not the same.
Right.
The insurance company, it's not the same as an unblemished automobile.
Right.
So where the diminished value or where the consumer is being taken advantage of is in the insurance settlement when that accident occurs. Mm-hmm. Case in point, a Mercedes that has a scratch on the bumper, it's cheaper to buy a replacement plastic bumper. The Mercedes dealer wants the VIN number of that vehicle in order to make sure that they get the correct part. That information is then sold to these reporting agencies and comes up as an accident because a bumper cover was replaced. Mm-hmm. Now, to me, that's where the diminished value should be addressed, is with the insurance companies, so that the consumers are made whole at that time, because their vehicle, if they accept it to be repaired, are down the road when they go to trade that vehicle in and we run a Carfax on them and our AutoCheck,
right.
This is going to show up.
Right. I mean, ideally, what would be best is for the information to follow with the vehicle all throughout the process. And we had a problem before when the information wasn't there and people were buying cars, and then all of a sudden they take it to a body shop 6 months after they bought the car and they say, look at this weld here, look at this, look at this. This thing had major damage on it. So it's all a question of degrees. Generally, the marketplace works better when the information's out there and people can make informed choices. You can make an informed choice whether to take that car and trade or how much to give them for it because of that damage. And the buyer from you or somebody else can take that into consideration as well. Usually, that leads to more vigorous and fair competition. You know, the situation you talk about, yeah, you know, a scratch on a bumper and that sort of thing. I mean, it can happen where that can get reported. And it's all a function, again, of state law as to whether there is any reimbursement for the consumer through the insurance policy. And sometimes some states do have that and some don't have for diminished value. But the bottom line is that if there's something that tarnishes the history of that vehicle, it's going to stick with it, and everybody needs to know it.
Well, every time we run a Carfax and report to the consumer, hey, this vehicle was involved in an accident and was reported by your insurance company, they said, we didn't know anything about that would be reported. We settled with the insurance company. So the insurance companies should be disclosing to the consumer, we're going to report this to an agency that's going to be on the internet and follow that car for the rest of its life.
Right. Well, those companies don't just pick up that. I mean, they pick up accidents reports in some states. They pick up the information from all kinds of sources.
Okay, a big hand for our panel.
Thank you, guys. Thank you.